The first question says, right, because what the act says is that, again, we're down here parsing still, may not deny and shall approve. Well, does that mean we have any choice at all? Have we got any authority whatsoever? And the first question is, well, can you even ask for an application? And the answer is yes. But you may only seek documentation about whether the changes meet the 6409A requirements. Like the Build Act, the municipality may not inquire about the need or the business case for such an additional structure. So we'll talk about it again a little later, but let me say it here. What this says is that if you're going to ask about the business case, then you better do it the first time somebody's asking for a tower, because once it's there, you cannot ask for any justification down the road. What you can simply do is you can ask, does it meet those six criteria that we just outlined? And again, understanding that the last of the criteria, the other non-subjective codes, might include a whole lot of other criteria, but that's it. So is it height? Is it width? Is it outside of the current boundaries? Does it defeat stealth? Is it in compliance with any other requirements? And if it doesn't, if it does all of those and it stays within, then it's entitled to the fast track. The next question is there a shot clock action for 6409 that's different from the existing shot clock? And the answer is yes. Yes. 6409A applications are entitled to have a response within 60 days. Please note that this is 30 days shorter than build. So you will need to adjust your process. I'm not saying that you have to adjust your law. We'll talk about that at the end, how you might want to respond, but you do have to adjust your process. There's a lot of jurisdictions around the country that cannot get things done today within 60 days. Just can't. The number of hearings, public publication, they can't get done. They're going to have to change out their process if they want to be in compliance. You can always go beyond 60 days by agreement of the parties, but you know, I've talked to the industry, and they're of a mind that yes, they're going to grant extensions, but they're going to grant extensions on day 50 if you're telling them that everything will be done by day 70. They're not going to grant extensions on day 1, and quite honestly, I don't blame them, because if they grant on day 1, that it won't happen. We're going to go through this timeline. You're going to see it time and time and time again. Understand that there are now 4 deadlines when you're dealing with an application. First deadline comes in on day 30. You have to tell the applicant whether or not their application is incomplete. That applies to both 6409 and 332. Day 60, you need to give them an answer on whether or not they're eligible under 6409 or deny. My position is that if you get a denial here under 6409, the applicant has to go back here and then make, oh, this is fun. You guys should never show me how to do this. Then they have to start all over again and come on a separate track now for a co-location under 332C7. If it's a new application, people are entitled to 150 days. There's also another mini shot clock. That is, if you tell somebody that their application is incomplete and they come back with a supplemental application, you only have 10 days in which to review that application to see if it's complete. And you are limited in your review to that which you said was missing to start with. So let's move on. We'll see each of those lessons again. If there is no grant or denial during that time period, the request is deemed granted. This is new. We will not see this in 332C7, but it is new. On day 60, they can send you a letter saying, we haven't heard from you. This is to let you know that under the statute, we are now going to pursue a deemed granted relief, and they can go forward. At that point, the burden of proof has shifted, and then the local government would have to go to court to try to get an injunction to stop it, rather than the other way around. The 60-day time period may be told by agreement of the parties or for incompleteness if local government gives specific notice of incompleteness in writing within 30 days. I want to make this very, very clear. We traditionally thought that you start here on day one, and it is the application is filed, and then we get out here today. Let me come back here. I'm sorry, I went too far. We get back here to day 29, and we find that it's incomplete, right? So it's missing things. It's incomplete. We always have told people that means if it's incomplete, we're still back here at day one, because we always said it was 60 days to review a complete application. I understand that is no longer the standard. The standard is if we're still here on day 29, you tell them it's incomplete. The clock is frozen on day 29 until they give you their supplemental application. Once they give you that supplemental application, the clock starts again. You've got 10 days to figure out whether or not it's complete. If you find on day 9 that it's not complete, the clock has not stopped until day 38, right? 29 plus 9, it's day 38. So that's a real difficulty, and I worry that if the second is incomplete, again, you've got to come back within 10 days and tell them that. If the second is incomplete, it could get very close to people running out of time to actually evaluate these things. Please note that that's a difference. After applicant responds, the shot clock runs again, but local government then has 10 additional days to toll if requested information is still missing. The 60-day period runs regardless of any local moratoria. You will hear this a number of times. Every time I do one of these programs, someone says, well, I'll just do a moratoria like I did in the past. The order specifically states that you cannot stop this. You cannot toll the 60 days by means of a moratoria. The FCC, after they wrote all these rules, said, oh, by the way, we don't want to resolve them. You go to court. You go to court to figure these things out. We're not going to resolve them. Everybody goes to court. All right, so what have we said? We've already talked about these other key lessons. What's our new key lesson? If a local government does not grant or deny a covered 6409A modification within 60 days, it is deemed granted by FCC rule. Again, they have to put you on notice that they're doing that, but it is deemed granted by the FCC rule. So we said that they created this whole new 6409 regime, but they also spoke to the traditional 332C7 world, and what did they say? Well, first of all, they said the good news is that they declined to adopt a deemed granted remedy under 332C7. So if someone is not entitled to the fast track of 6409, then they never get to deemed granted or claim it. Okay. The shot clocks for 6409 and 332 operate in 5 new ways, right? We've talked about this, but we're going to talk about it again because this is vitally important. The clock starts to run when the application is submitted, not when the application is deemed complete. After incompleteness, notice and response, local governments have only 10 days to notify the applicant that requested information is still missing, and remember the clock is running. Local governments must specify the code provision, ordinance, and the other publicly stated procedure that requires the missing information. And again, the shot clock runs regardless of local moratoria. Finally, the shot clock applies to DAS and small cells if they are used for personal wireless services. So those are the 5 new worlds of the shot clocks. The good news, again, is that the FCC made it very clear that proprietary rights are protected. This is very similar to the build but it does not go on to limit the price one may charge for rent or administrative fees, such as those imposed by build. There is no reference whatsoever to fees in 6409 order, and so unfortunately, you all live under the Build Act, which is quite honestly, it's unacceptable in terms of what they're limiting to. But as I said, GMA did a hell of a lot better job lobbying for you all at the state level than my colleagues and I did at the federal level. But that's one area that we were successful. So finally, we may not deny and shall approve. This is a recommendation, again, from my colleague, Trip May. Trip believes that a conditional approval is not tantamount to a denial. He points out that you can generally prohibit or invalidate conditions of approval that set limits lower than the criteria for a substantial change or impose subjective standards. He believes that it's probably still valid. Conditions include, we talked about this, drainage, landscaping, maintenance, lighting, fencing, access, indemnification, compliance with all general rules applicable. So again, this idea of granting a conditional approval is not so there. So, so here are some questions and answers that folks keep coming up with. What happens when the applicant wants to modify a legal non-conforming site? Does the deemed granted remedy apply to building and encroachment permits too? Can we deny a new site just because we don't want to see it get 20 feet taller? What happens when an applicant submits a project under 6409, but staff later determines it's not applicable? And how can we make sure that the application is, how can we make sure that the applications don't fall through the cracks? I think those are the challenges that you're facing. Modifying a legal non-conforming site, 6409 is applicable. You can get a fast track. Just because it's non-conforming today doesn't mean that it's not entitled to the fast track. So what you're looking for there is to make sure that they're not entitled to the fast track because the non-conforming site is not entitled to 332C7 typically. Does the deemed granted remedy apply to building and encroachment permits too? It applies to everything. It applies to everything. Well, let me rephrase it. The FCC and the industry would believe that a deemed granted applies to everything. We don't believe that that's the case. We also believe that that's part of the basis for the appeal that we'll be taking for a number of clients under the 10th Amendment. Can we deny a new site just because we don't want to see it get 20 feet taller? I think the answer is yes. So long as you're not prohibited under 332 C7 from on other grounds. I'm not sure that I would necessarily use that as my only grounds, but it seems to me that if something can grow 20 feet taller and you're keeping faith with the local community, that yes, that would be justifiable grounds. You want to obviously do it in writing. So that the Supreme Court doesn't have to review whether or not what you've done is in writing or not. Little insight there to another Georgia municipality that's in front of the court now. And how can we make sure that applications don't fall through the cracks? And I think the answer to that is you need to create processes and structures so that that doesn't happen. I'm going to skip the next couple of pages other than to say to you, please know that the order dealt with the National Environmental Protection Act and the National Historic Preservation Act. Both of these have standards that need to be met, but you typically will not be the decider. You will not be the arbiter. And so that's why we're talking about conditional permits. That is the way that you might want to go if any of these things are in play. Again, one of the biggest problems would be that people will see this and they'll think that they can fight or slow these things from moving forward. Most of these rules are dealing with the feds and not us. And so again, know that they're there. I wouldn't spend a lot of time on it. I think I would be making sure that I've got my structures in place. The other area is temporary towers, or what a lot of people call things like CALs, that is communications on wheels. What these things are is they're the types of devices that are brought in after storms, or they're brought in when the SEC is playing at the Georgia Dome, or big events where there's not capacity. What the rule does is that it codifies a previous waiver for temporary towers that are not subject to environmental assessment, so long as they're only going to be placed for 60 days, and that they don't have to provide construction notice to the FAA. That is, they're not in the flight path, and the marking and the lighting meets FAA requirements, that they're no higher than 200 feet. They involve no or only minimal ground excavation. Again, this is an issue that local government likes, because when you need them, you need them. So what we're going to do now is sort of outline what we think the local government responses and the timelines are. So the FCC order is issued. I believe that there are three different responses. There's a legal response, there's your local regulatory response, and then there's the planning or the practical response, and each of those has got a time frame. The first question that we have, and it's not on here, so let me just put this up here, is this is the 10-day rule, right? If you decide that you want to appeal and you think that you have one jurisdiction, one circuit court that's better than another, then you want to file your appeal within 10 days. We believe right now that the Fourth Circuit, which is the Maryland, Virginia area, the Seventh Circuit, which is the Chicago area, and the Ninth Circuit, which is out in California, are the three best circuits in terms of respecting local government rights in this area. And our hope is to assemble a coalition to attack this and to have a representative from one of those three jurisdictions serve as our lead appellant, so that we can get into one of those. But that's the first deadline, that's 10 days. 30 days after federal publication, you have to file for reconsideration. Right now, we're trying to advise folks not to file for reconsideration, because what happens is that when an order is when reconsideration is requested, the actual appeal gets stayed until they can figure it out. Appeals have to be filed within 60 days after Federal Register publication. If you file within 60 days and there are multiple people, then it goes to a lottery. You have one, the question is whether or not your favorite circuit comes out of the envelope. And we'd like to sort of copper our bets as best we could by trying to get in within 10 days. The order will take effect 90 days after Federal Register publication. Again, there's some nuance, again, because of the LMB, but for purposes of today, so we've got 90 days to figure out what your code says, what your regulations say, figure out what your forms and existing timeframes are. You've got 90 days to change that out, but I think the time is now to sort of be understanding and figuring out what those changes might want to be. And then I also think that since we know what the rules are, you ought to be making sure that you're policing your lease terms today to ensure that co-locations require owner approval. As I said, I do a lot of these types of agreements for local governments. A lot of times they're renewals or extensions, and so many times people granted the ability for the tenant to co-locate with others without any oversight. Please don't do that. Okay? So again, reconsideration is federal registration plus 30 days. I'm sorry. Reconsideration is federal registration plus 30. Petition for review or appeal is federal registration plus 60 days. Again, these would be some of the grounds that we think that are worthy to take up on appeal. One, that the commission's definition of substantially change the physical dimensions is unreasonable and arbitrary. We're not sure how you could have something be 20 times taller and 80 times wider, how that does not substantially change the physical dimensions of the tower. Our position is that the FCC unreasonably defines base station to allow modifications of buildings, lights, signs, and other structures that are not base stations. Again, we think the Build Act has it right. The base station is the equipment. It was not the underlying structure. You could argue that under 6409, a 10-story building could grow to 11 stories so long as it's complied with all the rules without getting a permit. We're not sure that that's going to happen, but that's certainly an interpretation that you can do it. And then finally, we believe that the commission unreasonably or unconstitutionally deems that a local or government approval of an application when we in fact have not done that. So here are some of the things I think that you should do and some of the things I think that you should not do. I think the first thing you want to do is you want to ensure that everyone in your organization understands this new rule and that it does not grant the right of free locations on government property, but it does grant additional responsibilities and additional obligations on your whole structure. We want to make sure that you don't grant any right in your leases without requiring prior approval in writing by the municipality, the special district, whoever it happens to be for changes. What you also want to do is you want to ensure that the industry does not use these new rules as an excuse to install generators at your sites. We've already seen this a couple of different places. For years, the industry has said that they're required to put generators in place under the FCC rules. There is no such rule. But that's what they tried to do as a way of not paying for the additional new space. Make sure that your people understand that while the definition of what constitutes the base station includes generators, you are not granted the right to come in a proprietary fashion and take over your space. One would think that you are allowed right up front to require that the applicant choose what statutory term they're seeking approval under. Is it 332 or is it 6409? In so doing, I should change that. In so doing, they establish the timeline, that you understand the timelines that you're working under. You need to understand that there are 3 shot clocks and that the federal times do not extend shorter state timelines. That's applicable to you all. You've got 90 days under the build. Not for 6409, you've got 60 days, right? And you are limited when you say that something is incomplete, you are limited to what you first list as missing. There's no opportunity to add discoveries. I think you need to change your applications right up front. I think that you need to list those criteria that the commission said that you're allowed to check. So does it meet the size change? Does it meet the stealth obligation? Does it meet building code obligations? Does it meet safety code? Does it meet any other non-discretionary structural type code? Does it meet with any condition of approval of construction or modification that was imposed upon it when it was first delivered? Things like fencing, access to the site, drainage, and other conditions. Make sure that you have all of that on your application going in so that you'll know what's missing. Fees are not addressed in the FCC order, but again, they are addressed in the Build Act. Make sure that you comply with Georgia law. It's not clear that you can demand documentation that the site complies with the federal requirements, things like FAA, NEPA, NEMA, historic, Section 106 is historic preservations. It is not clear what the status is of local historic preservation limits. And I put that in there specifically because I know that folks down in Savannah, that's important to you. I mean, that's the same question that we've been asked a number of times by our clients, for instance, San Antonio, wanting to know for the Alamo area. It's just not clear what the status is, and so I would be very cautious there. The don'ts, right? Don't impose a moratorium. It's meaningless. It's meaningless. Don't approve any facility going forward without understanding how that can grow. So the smallest facility can grow an additional 10 feet up and 6 feet out. Please do not demand documentation for the business need for the proposed modification. Now, again, George is ahead of it. You weren't allowed to do that under the Build Act, so you're already ahead. So the question is, how do you build or not build a response? We're not here to tell you that you ought to accept the rule. I mean, there are some people out there that are going to fight it. they're just not going to accept it. Others may do something simple, and that is you preserve your existing standards, but you clarify that they apply unless they're preempted by federal law or rule. That might be a simple one-line ordinance or resolution. Well, the other thing is that you might look at your rules and you may allow a larger class of facilities by right. That is, if you do not permit a wireless deployment, right? If you don't require it to be permitted, then it can't grow. It only gets to grow after you've permitted it. So there may be times, a specific example, there are a lot of Starbucks and other coffee type shops that have wireless deployments, and sometimes they have them on the outside because they want to be able to sort of create a nice environment for their clientele. Well, most of the times you don't permit those. If you did permit them, they could grow to 10 by 6. So the other question is, should you be thinking about what it is that you want to permit? Because once you permit it, it can grow. Then you might want to think about other permissible regulatory changes that could reduce this rule's adverse impact. So things like maybe you enact an ordinance that favors placement on municipal property. Maybe you require significant proof of the need at time of initial installation. Maybe what you do is you require that every installation going forward have some sort of a concealment element so that you can later enforce that concealment element on a 6409 co-location. Because remember, if the concealment element isn't present at the beginning, you cannot insert it as a condition for a 6409A type of growth. And then you might want to separate your zoning and your right-of-way control. A lot of communities, as we said, already do this, but what you could do is you could regulate right-of-way placement through a generalized ordinance and franchise agreements as opposed to permits. And then finally, the last standard is sort of the surrender, and that is you simply incorporate the FCC standards as the town and the municipality's own. I'm going to review very quickly where I think the rule differs with BUILD. Like 6409, BUILD provides a streamlined approval process, but it applies to a narrower class of co-location than 6409. BUILD is limited to cellular. 6409 is any wireless service. There's no overall height or width change to the base station under BUILD there is under 6409, and there's no growth of the equipment permitted under BUILD. Again, that doesn't matter because BUILD is therefore preempted in those rights. So I think that the rule of thumb is that if you're looking at BUILD and 6409 and you're trying to figure which one gives you greater protection, that won't apply. So when you look at the two rules, the way you harmonize them is I think you need to read them both in the worst case against you to be safe. Again, the FCC's substantial change versus BUILD. Again, base station under 6409, not under BUILD. Equipment compound can grow under 6409, but not under BUILD. Under BUILD, local governments can impose any condition, including height and width, on the underlying structures and facilities. This also appears how local governments would have addressed aesthetics. None of that will apply under 6409, or at least we suspect that's the argument that will be made. 6409 and BUILD both require that modifications or co-locations comply with applicable conditions of approval, if any that were applied to the initial deployment. Both apply only to modifications of and co-locations to facilities that were previously approved. Now that may seem like a duh statement, but it's vitally important that the step one is whether or not you would approve this underlying facility. If you didn't approve the underlying facility, then neither 6409 or BUILD apply. Neither 6409 or BUILD permit local governments to inquire as to the business case. Now, I apologize, that's the fifth time you've heard that, but it's there. BUILD goes a little bit further in that it bans technical or service characteristics, but it does permit you to ask questions about RF interference and interference with public safety communications. maybe one of the things that you do is you pass an ordinance that says that any wireless deployment, has to be examined for RF interference and cannot interrupt or interfere with public safety communications. And maybe I don't even say wireless, maybe it's any deployment in the city, and that way you could say it was a subjective standard. Timeline. Bill provides 90 days for co-location, 150 days to active and new. Remember, it's the same under 332C7. 6409 is the 60 days. Bill allows tolling with written notice 30 days after the application is submitted. The completeness notice can only pertain to matters enumerated in regulations, ordinances, and forms. That's almost identical to 6409. So again, that shouldn't be something new for Georgia. Local government may not require placement on local government property instead of elsewhere. That's what Bill says. I still think there's an open question as to whether or not there's a difference between offering a preference versus a mandate. And again, Georgia practitioners are more than able to make that argument as well, if not better than I, or you can tell me I'm just dead wrong. Again, fees, only Bill limits regulatory fees, only Bill limits proprietary rental charges to fair market. Again, as I said in the beginning, it really shouldn't be an issue. There are so many ways to address that and to get around that or to comply with that. And that's it.